Section 23. Enforcement by the Attorney General. Arizona Fair Housing 101. When a fair housing issue becomes bigger than one transaction. Sarah looked across David's desk. We've talked about complaints. We've talked about investigations. We've talked about hearings. We've even discussed judicial review. She paused. So where does the United States Attorney General fit into all of this? David smiled. Most fair housing cases never involve the Attorney General. But when they do, it's usually because the issue is much larger than a single transaction. Pattern or practice discrimination. David explained that the Attorney General may become involved when there is reasonable cause to believe that a person, brokerage, landlord, builder, lender, or other housing provider has engaged in a pattern or practice of discrimination. Sarah asked, "What does pattern or practice mean?" It means the evidence suggests the discrimination isn't an isolated mistake. It appears to be repeated conduct. Rather than involving only one buyer or one seller, these cases often involve multiple victims or ongoing discriminatory business practices. When discrimination becomes systemic, David explained, the federal government has a strong interest in protecting the public. Matters of public importance, David continued, the Attorney General may also become involved when a fair housing violation raises an issue of general public importance. Sarah thought about that. So even if there is only one complaint, it could still affect many people. Exactly. Some cases establish important legal principles that impact communities, industries, or housing practices across the country. Those cases may warrant additional federal involvement to ensure fair housing laws are applied consistently. When appropriate, the Attorney General may file a civil action in federal court, seeking relief for individuals who have been harmed by unlawful housing discrimination. Depending on the circumstances, the court may order corrective action, monetary relief authorized by law, changes to discriminatory policies, or other remedies designed to protect the public and prevent future violations. The purpose isn't simply punishment, David explained. It's also to stop discrimination before it affects additional people. Cooperation between agencies. Sarah noticed another provision in the Fair Housing Act. It mentions state and local agencies. It does. David explained that HUD regularly works with state and local fair housing agencies through cooperative agreements. Arizona agencies may investigate certain complaints while coordinating with federal authorities when appropriate. This partnership allows fair housing complaints to be handled more efficiently. It also helps ensure that consumers receive consistent protection under both state and federal law. Interference, threats, and intimidation. David became more serious. One section of the Fair Housing Act is often overlooked. It prohibits more than discrimination. It also prohibits interfering with someone's fair housing rights. Sarah looked surprised. What does that include? Federal law prohibits threatening, intimidating, coercing, or interfering with individuals because they exercise or help someone else exercise their fair housing rights. Examples may include threatening a tenant for filing a fair housing complaint, intimidating a buyer because they purchased a home in a particular neighborhood, retaliating against someone who serves as a witness during a fair housing investigation, discouraging another person from exercising their fair housing rights. Fair housing protects people who seek equal housing opportunities, David explained. It also protects those who help others obtain those rights. Professional responsibility. Sarah leaned back. I've noticed something throughout this course. David smiled. Go ahead. Most fair housing violations don't begin with complicated legal questions. They begin with everyday business decisions. David nodded. They do. An advertisement, a showing, a conversation, a policy, a refusal. That's why professionalism matters. The small decisions we make every day determine whether we remain compliant. The bigger lesson, Sarah closed her notebook. I understand now why the Attorney General rarely becomes involved. David smiled. Why is that? Because if brokers consistently follow fair housing laws, treat every consumer equally, and correct problems early, most situations never reach that level. David laughed. Exactly. The Attorney General becomes involved when discrimination grows beyond a single mistake. Our goal is to prevent it from ever reaching that point. Arizona broker tip. One fair housing complaint can often be resolved through education and corrective action. However, repeated discriminatory practices, brokerage policies that treat protected classes differently, or intentional violations may expose a licensee or brokerage to much broader enforcement. Building a culture of compliance is one of the most valuable investments any brokerage can make. Online discussion question 1. What is generally meant by a pattern or practice of discrimination under the Fair Housing Act? Answer. A pattern or practice involves repeated or systemic discriminatory conduct rather than a single isolated incident. These cases often affect multiple individuals and may justify enforcement by the United States Attorney General. Question 2. Why does the Fair Housing Act prohibit intimidation or retaliation against individuals who exercise their fair housing rights? The law protects not only those seeking housing, but also those who file complaints, serve as witnesses, or assist others in exercising their fair housing rights. This encourages individuals to report discrimination without fear of retaliation. Question 3. How can a brokerage reduce the risk of becoming involved in a pattern or practice investigation? Answer. By adopting consistent office policies, providing ongoing fair housing training, documenting transactions, supervising licensees, and treating every consumer fairly and equally, regardless of protected class status.